a group swearing-in ceremony. So if you could all, you're already standing, if you could please raise your right hand and then repeat after me. I, your name, do solemnly affirm that I will support and defend and bear true faith and allegiance to the Constitution of the United States and to the Constitution of the State of California. Against all enemies, foreign and domestic. That I take this obligation freely. Without any mental reservation or purpose of evasion. And that I will well and faithfully discharge. The duties upon which I am about to enter. Thank you very much. If you could please sign your form, and I will file that with the city clerk. I have the pleasure of sitting in for the city clerk tonight as the deputy city clerk.
So you can tell I was super anxious to get rid of the gavel. And the next thing we have on the agenda is the selection of the chairman. And so what we need to do is have one or more nominations and then close the nominations and vote as to who will be the chair. And then I'll pass the gavel to whoever that is, and they can do the selection of the vice chair. We did have in the ordinance the selection of a secretary. And after we select the chair and the vice chair, I think Mr. Fletcher has a suggestion on how that should be handled. But it's not on the agenda tonight. So are there any nominations for chair?
I nominate Bill Butters.
Okay.
Second.
Okay, any further nominations? So the nominations are closed, and I'll just call for a voice vote. All in favor?
Aye.
Opposed? Okay, congratulations. You get a gavel. In fact, usually, why don't you swap seats with
More
Bob?
potential to embarrass myself. Okay, am I supposed to use this, or we're already in session?
So,
We can go ahead with nominations for vice.
yeah, we can. I was reminded that if you want to speak, you need to push the button and get a green light, and then turn it off when you're done, or else you'll be going, broadcasting on the tape.
Okay, mic's on. Nominations for vice chair.
I nominate Tom Farmer.
I hear a second.
I second.
Any other nominations? I guess we'll close nominations, and all in favor of Tom Harmon as vice chair? Aye. Any opposed? All right. Discussion of secretary.
Thank you, Mr. Chairman, members of the board. As first lesson on procedure tonight, we realized that we did not agendize appointment of a secretary, and the ordinance that we adopted here called for the board to appoint a secretary. Upon reflection, actually, I was talking to the chief building official myself, we're going to recommend that be changed, because normally the secretary of a board is a staff person that's assigned by code, and it's just the clerk for the city council, it's the building official secretary for the planning commission. So we have a real secretary working here, Sherry, who does all the planning commission secretary work already here, taking care of our minutes and everything tonight. We're going to recommend to the city council that we change that and simply, when we bring the building code back for adoption later, early next year, we simply make a code change and clarify that the building official or his or her designee shall serve as secretary of the board. That way you're always assured of having a rotation of the secretary.
And so we could proceed by simply accepting that recommendation and selecting tonight? Or
No, just don't need to do anything.
Don't need
We
to
will
do
have your
anything?
minute. We will have your minutes. They will be prepared. There's no issue about having a record tonight. So we will next year. And if we wind up with a hearing before early next year, then we will have you appoint somebody who would be the same person anyway.
Everybody okay with that? So the next Oh, Pledge of Allegiance. Roll call, okay. You do that, yeah. I'm very rusty, so everyone's just going to have to wait for that.
Okay. Board
Very
member-
green.
Board Member Chair Wyrick.
Here.
Board Member Vice Chair Farmer. Board Member Daddy. Board Member Hanson. Board Member Hilgers. Thank you.
Pledge of Allegiance.
and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, you'll have to make sure I do this right, but understand the next agenda item is public communications, and that's if there's anyone in the audience that wishes to bring a concern at our first meeting here that for us to consider that's other than on the agenda. Is there anybody that wishes to come forward and say anything? Okay, thank you. All right, discussion of building appeals board duties, Brown Act, etc. I believe that's your
Thank you, Mr. Chairman, members of the board. I'm Joseph Fletcher. I'm the city attorney, and we decided we'd start tonight's meeting with a relatively brief orientation I call Local Government 101. I prepared this presentation several other times throughout my career as an orientation to the general structure of the city government and some basic statutory and procedural things that all boards and commission members ought to be aware of as they enter into their duties. So I won't, and I'll treat this as a seminar setting. So if any questions, stop me, ask questions. This is an opportunity for you. Some of this stuff is going to be fairly obscure, depending how much experience you had doing other local government work. So this is your opportunity to ask questions and talk through things that may come up. We're going to talk about structure of government, statutes such as the Brown Act, the Public Records Act, Brown Act and the Public Reform Act. We'll also talk about some statutes that affect your jurisdiction as the Board of Building Appeals, as well as how to conduct hearings and make findings. So, in California, there's two types of cities: general law cities, whose power comes from the legislature. Ojai is a general law city. And charter cities, whose powers are granted by the California Constitution and governed by our voter-approved charter. Some states it's called home rule power. The important distinction is for charter cities, they may legislate any matters of municipal affairs, that's a magic term, that are not inconsistent with, and not inconsistent with state law. Over the particularly the last 50 to 75 years in California especially, home rule power has been greatly narrowed. And only recently, a lot with the fiscal crisis and state budget crisis, there's been more conversations about the pros and cons of home rule. In any event, even in matters of home rule, if the state legislature has acted to occupy the entire field, local government can't regulate. And the best example for that is the vehicle code. Many years, shortly before World War II, I believe it was, the state adopted the first vehicle code. And so the operation of motor vehicles, ownership and operation of motor vehicles in the state of California is a matter of statewide concern. You can't have different vehicle laws as you cross city limits and between cities and counties. Therefore, the vehicle code is the law of the state, irrespective of whether you're a general law city or a charter city. And then the legislature gives back to local government through the vehicle code the ability to adopt local regulations such as parking regulations, vehicles height regulations, truck routes, and things like that. Important things to know about the general law city powers. California Constitution, Article 11, Section 7, a city may make and enforce within its limits all local, police, sanitary, and other ordinances and regulations not in conflict with the general laws. So to the extent the state has not regulated in an area, we have the authority as a general law city to legislate. City organization is all set forth by state law, the Government Code sections 34851 through 34906, and this deals with how city council is formed, offices of the city council, city manager form of government, city clerks, planning commissions, planning law, all that's covered in the Government Code. We don't have to adopt local ordinances to address those offices. Major statutes affecting the Commission: the Ralph M. Brown Act, the Political Reform Act, and Government Code Section 1090, which are the primary conflict of interest statutes in the state of California. Ralph M. Brown Act. Ralph Brown was the Speaker of the Assembly in the mid-1950s, and he was the sponsor of the bill that we all know a lot of states call as open meeting laws, Sunshine Acts. California had one of the first ones, which is we all know is the Brown Act. Basic principle of the Brown Act is all meetings of legislative bodies must be open for public participation. And the two important principles are, one, the meeting is open, and that the public has an opportunity to participate in the meeting. And an important point is, and this is in the statute, which has now been made part of the Constitution. So the concept of the Brown Act and open meeting laws is a matter of constitutional law in California. And it's the intent of the law that public agencies, including, for example, the Board of Bill Appeals, actions be taken openly and deliberations are conducted openly. So it's not just voting. The really important part we'll really try to focus on, it's not just taking the action. It's the process of deliberation must be done publicly and openly. What's a legislative body? Of course, City Council, Board of Supervisors. A legislative body is also any committee or commission formed by formal action of a legislative body. Therefore, Board of Building Appeals is a legislative body for purposes of the Brown Act. That can also be any other entity that they formed, any sort of advisory group, even if it's formed by does take an ordinance, voting to appoint a group of people to carry out some function to advise the council. They would be a Brown Act body. And in the narrow case of governing bodies of a private entity, which is created by or funded by the city and contains a member of the legislative body on their board. Some cities have private nonprofit corporations, housing corporations. A lot of cities have private housing corporations that do their affordable housing development. Sometimes chambers of commerce. If they're actually formed by the city or a council member sits on them, they could be wind up as a Brown Act body. Here's the important point. What constitutes a meeting? Any congregation of a quorum to hear, discuss, or deliberate on an item within the jurisdiction of the body. So it's not even just taking a vote. The best example of the hearing is the case that it was a number of years ago. A school board, a majority of the school board met in a private meeting to talk to receive pitches by textbook manufacturer publishers. They weren't going to take any vote. They weren't going to discuss it. They're just going to listen to the presentations from the various publishers of the textbooks. Courts held that since that was part of the deliberation process, receiving information they're going to use to decide which textbooks to use, that was a violation of the Brown Act to have done that in a private meeting.
Mr. Fletcher, you said to break in. I have a question on that. So as I understand it, when you come to, I want to be clear about this dissemination of information.
Mm-hmm.
So let's say that I, as a chair, have a document that I want to share with the rest of the board. Normal thing that would occur to someone who's not in government is to attach it to an email and send it out. Is that not, and I know I understand reply and discussion, that's clearly out, but is the dissemination of that kind of thing, so how is that to be done in terms of dissemination of information if the dissemination of a document without reply or further discussion, if that's a violation of the Brown Act then? By email?
We'll discuss emails more because they're extremely dangerous in terms of the Brown Act. But
well, that's why I'm asking.
So I have another section. I have a couple more slides.
Okay, another section.
But start by saying that first it starts with a congregation of members. So obviously, if we're dealing with if it's a communication other than you getting together, if you're looking around, you see two of your colleagues with you, something should happen. Especially no action should happen. But you're getting you're already getting into the weeds in terms of other communications. But yes, the answer is there's an issue there. But we start off with first as any physical meetings. You must meet within the city limits of the city. And here we're getting into the issue we're talking about, serial meetings. There's two types of serial meetings. It's any communication, obviously not just a congregation of people. Employed by a quorum to develop a collective concurrence is a serial meeting. And there are two types of serial meetings. Daisy chain, which is a process where chairman talks to another member, who then talks to another member, who talks to another member, and as long as they're sharing information in that process, that can constitute a Brown Act violation. And this is where I talk about the issue is, and the most dangerous thing, of course, is that it's not used to be it's a phone call. If you just don't call your colleagues, it's not going to be a problem. If you send I'll address now maybe your memo, one-way communications. Write a memo, old-fashioned, put on a piece of paper and send it to somebody. It's a one-way communication, is not a Brown Act violation. You can send memos to all your colleagues, to the staff, to whoever it might be. In a one-way communication, you're not developing a concurrence. The danger, of course, is when that becomes an electronic memo in an email that's easily commented on. I like this idea, boom, and it gets, and more importantly, it gets reply all. And therefore, you're now you got communications going back and forth that can constitute that concurrence.
So to be clear, the way to share documents and be safe, what you're saying is to do with snail mail or personal handoff.
Right.
Okay.
Yes. I mean, clearly, and yes. And I know I'm fighting against a strong wind on this, but when it comes to the actions of boards and commissions and councils, so I got my bosses here. My advice is to just avoid the natural instinct today to send an email about something. It's just because, and I remember I take you back to one of the early conversations, this is a matter of constitutional law in the state of California. I think we are long past the day, we should be long past the day, where folks say, oh, that is silly, what an obscure rule, that's how do you get business done if you can't talk to each other. I think hopefully we're past that point that it is. That's the rule of how we do business, and it's very clear. If you look at any of the scandals that have gone on in the last few years around the state about local government, there's the public has not a lot of respect for that process, and so arguing why it's a lousy way to do business is generally a waste of a lot of energy. So my advice is to really avoid emails among members on business, of course. Email, hey, barbecue Saturday afternoon, different issue unless all 5 of you are going to the barbecue, which we will discuss in a moment.
And another specific question on that. I'm not an attorney, obviously, but I did read the Brown Act, and there was an element in there about it's okay to communicate about the arrangements for setting up meetings.
Yes, there are certain exceptions. For example,
We can do that by email, in other words.
Yes.
Okay.
And we'll do that all the time. You'll get emails from Rob or the staff saying, hey, we need, particularly in the case of where you're going to call meetings primarily on an as-needed basis. We got an appeal. I need to know people's calendar. Please let us know what your calendars are. Yes, the organizational type of communications are fine. The other type of serial meetings is a hub and spoke, and that's where only one person. This is a really dangerous one. This is where you be aware for yourself, and it's important to be aware for members of the public, because even a person who can, you as a board member, could not be aware that you're part of this because you've only talked to one person, and that's where one individual. This happens a lot in the lobbying scenario, where an individual contacts each member of the board or each member of the city council or each member of the planning commission and tries to lobby or communicate about something. And you may have met with this person or talked to this person. That's all I know is I talked to this person. Well, that person talked to a majority of the member of the body and passed on their feedback. And that can be done even more unintentionally. So both of those situations, if you are communicating with a colleague or a member of the staff, and you want to convey your position on something about a matter, it's very important. It's one way, and you make sure you never talk to more than one other member of the body.
And if we get lobbied by a member of the public, we just listen.
And I'll tell you, we get into also the process. My advice, my very strong advice in terms of on an appeals board like you is you shouldn't be lobbied, period. You should say, I cannot take any. And we'll get into ex parte communications and administrative record, but as an appeals body, you shouldn't be talking to people outside the hearing, because you'll be conducting a quasi-adjudicatory hearing, and all that evidence needs to be submitted here in the hearing room and not received outside. And so whereas city council members or members of the legislature, There's a constitutional right to seek redress of grievances to your elected officials. There's special exceptions for elected officials that don't really apply to hearing boards. So let's talk about less than meetings and less than a quorum. Obviously, and we're talking about 2 or fewer since you're a 5-member body. And a quorum is 3. So we're talking. So we have 2 things, and the exception to the Brown Act for committees is that a committee is a Brown Act body unless. So if you form a committee and a committee is less than 3, you should start with the assumption that committee is a Brown Act body. Because remember, as I said, any entity created by a Brown Act body is a Brown Act body. So you start with the assumption we're going to appoint a committee to do something. Assume that it's going to be a Brown Act body, which means they must have noticed the open, publicly noticed meetings. That's all that means. We've developed, these terms aren't in the statute. These terms we have developed in practice to help distinguish the issues of committees. A standing committee has a specific task, long or no end, long activity period or no end, and they are subject to the Brown Act. And that's obviously anything the sort of, we want to have a group that's going to have a regular responsibility to deal with an issue or deal with certain people, or then that is going to be a standing committee and subject to the Brown Act. The exception to this committee rule is ad hoc committees. Again, this is a term that you won't find in the Brown Act. And it's the exception is that a committee, to be an ad hoc committee, it must have a narrow purpose. We're going to form a committee to choose, a nominating committee for next year's chair. And so we'll appoint a committee. They will meet for the purpose of coming back with nominations for next year's chair. And when they're done, they're dissolved. They're not a Brown Act body. 2 things you can't do. You can't have annual ad hoc committees. This is the 2013-2014 ad hoc finance committee, and next year's the 2015-16 ad hoc finance committee. That meets all year long. It's just that we change it every year. That's not going to pass muster in terms of ad hoc. So the most important thing is that they have they're constituted for a limited purpose and then dissolved.
To put a little meat on that bone,
Sure.
If we're talking 3 to 6 months, we're safe. If we have a study committee on a issue, for example.
I think particularly we tie it to
the advisory function.
And
yeah.
say for example, we're coming out with the 2013 building code.
Mm-hmm.
If it seemed worthwhile to have a committee of 2 people meet on a regular basis with the city staff as they start noodling through it, so they can really have in-depth knowledge of some of the issues or something, that would be fine. And the fact that it's not 3, 6, it's not 6 months, it's not 9 months. It's really the limited scope. And then importantly is disband. If we find yourself doing that, appointing another committee to do the same thing that another ad hoc committee just did, it's probably not an ad hoc committee. Major exceptions, my barbecue exception here. Attending conferences, you may have an opportunity to attend league conferences, or particularly for you since you're at a technical advisory board, it might be attending some training sessions put on by are we still the International Congress? Are we still the International Code-Council? Used to be the International Congress of Building Officials. It was a much better name. It sounded very important because they were a Congress. It's a much, International Code Council now. So if you want to attend, they may put on training, and you go to down to LA or someplace or Ventura for attending a training class. Even though all 5 of you are there, that's fine. Attending, if all 5 of you are here at a city council meeting, it's a noticed public meeting of another body, that's fine. Let me back up. Provided you don't discuss business among yourselves at that meeting. Purely social gatherings, purely social gatherings. This is a small community, and you're at a barbecue and you look around the backyard and there's 3 of us here. It doesn't mean you got to run off to scurry off to the corners of the backyard. But you are responsible. Each is responsible for making sure you don't wind up talking business while you're there. So we'll take that up next time. But and then go ahead and watch the Super Bowl. It's totally fine. And then community meetings. This is an important one for a small community like this. Community meetings organized by somebody else. If the city, if we notice a community meeting to talk about code enforcement issues in a neighborhood, so it's organized by the city, you cannot attend, a majority of this board couldn't attend that. But the school board, if the school district puts on a community meeting to talk about something, it's someone else's meeting, not ours. You can attend, the majority of you can attend that. Again, so long as you, during the meeting, you don't discuss business among yourselves. What is an action? A decision made by a majority of the members is an action. A promise to make a decision is a decision. You don't want to do that. Actually taking the vote. So basically, it doesn't take a whole lot to constitute an action. That's the important point to keep in mind. Here I go. Ex parte commitment contacts. They are prohibited because you're not a legislative body, and particularly for you because you're going to be, the vast majority of the time, acting in a adjudicatory, judge-like fashion. Therefore, the evidence before you is very important. You need to reconstitute what the evidence was before you make it, upon which you base your decision. Therefore, it's very important you not be lobbying. And I'll give you a really easy out to say, look, I'm not allowed to talk to you. Come to the meeting. I want to hear what you have to say, but please, I don't want to talk to you. And if you get into it, and particularly if you get into an appeal, you should not ever meet with the appellant outside of the confines of this room. If an ex parte contact happens accidentally, the most important point is to put on the record, hey, I was over at Seafresh, joined my dinner, the applicant came down and sat in front of me and started telling me what all this was all about. Well, I met with him, I really couldn't leave, but here's what I was told. Put it on the record so everyone knows what information received. Agenda process, we just went through this. Agenda must have a brief but reasonable description of each item of business to be transacted. The important point is it's not what the vote's going to be. We're here to discuss appointment of the secretary, not who is going to be or how we're going to decide to do it. That's all it has to be. Your regular meetings, and we aren't proposing regular meetings of this body. Regular meetings must be posted publicly 72 hours in advance. Special meetings only have to be posted 24 hours in advance. We send special notice to the media. It's your decision whether to hold regular meetings or not. Historically, we haven't done that with boards of building appeals because the issues are so sporadic that you wind up calling a meeting and then canceling because there's nothing on the agenda. Which means most of the meetings you're going to have are going to be posted 24 hours in advance, and they'll all be treated as special meetings. Important point: Brown Act does not allow discussion or action on items not on the agenda. You already know that. You've already lived it. What you can do, of course, you've heard the mayor say this at every council meeting, you can briefly respond to comments or questions from the public. You can put it on a future agenda. You can ask questions for clarification. I can't contemplate a situation where the emergency exception would come into play for a board like you. City council, we have an issue come up, we've got to take an action, something's happened, fire, disaster, something, we need to take an emergency action, then there's a procedure in the Brown Act where we can do that. I can't contemplate that a board like you would ever have grounds for an exception to that rule. Public comment section. The important point there's a couple of important points for you. As we did, on your agenda, every regular meeting agenda must have an opportunity for the public to address the body on its jurisdiction. You're a limited jurisdiction body, Board of Building Appeals. You're not the City Council, you're not the Planning Commission, you're not the Arts Commission. So you can limit public comment to matters within your jurisdiction, which can be more narrow than what the City Council may face. It has to be meaningful. I'm happy to say that Ojai is not a community with a big problem with a lot of off-the-topic public comment where people want to talk about world peace in Syria and whatever it might be. A lot of communities face that issue a lot, and again, you have to tell it's not in our jurisdiction. The federal budget, the budget stalemate is not a matter of local concern. We don't have any jurisdiction over the federal budget, so no, I really don't want to listen to you talk about the federal budget. And of course, then you must be allowed to speak on agenda items before or during consideration, of course, needless to say. If you're having a study session, we may do this when it comes up when we're getting to the building code adoption. In that case, when you're having a study session, sometimes it makes more sense to since you're not going to take an action, you can take public comment after you've had your study session because maybe it makes more sense. Folks have listened to what's gone on and they can comment on it. Most important point is you have to, before you take an action, the public's entitled to comment on it. A violation of the Brown Act can be a crime. So just keep that in mind. It has to be a knowing and intentional violation. I don't know of a conviction in the state of California, but you don't want to get a phone call, letter, or any news story from the DA about a Brown Act case up in Ojai. They're rare, extremely rare. More importantly, more often, it's a civil lawsuit brought by somebody who's unhappy with an action or non-action or how a process went down. And so more likely it's a civil lawsuit brought to set aside or enjoin, undo what the body did. Here's an important point. This is really a message more for the city council than for you. The big cost is you pay the attorney's fees. We, the city, pays the attorney's fees, and so you get a Brown Act lawsuit. All they have to do is to make some change in city practice as a result of their alleged lawsuit. You get their attorney's fees. It's not hard to get to 6 figures on a lawsuit like that pretty quickly. So that's a real impediment to, a real reminder to play it, try to be clean. Yes, sir.
I have a question. I want to be clear about something.
Yeah.
The ordinance has basically really 2 functions. There's the hearing of appeals,
Right.
and then there's an advisory role. Is there a difference in terms of engaging the public between the 2? I certainly understand the appeals aspect, no contact if ideally, or
Right.
prevent it if at all possible. What about the advisory function?
We're going to get into legislative versus judicatory real quickly, but the answer is
I
there's
keep jumping the gun. I'm sorry.
You're good. You're good. You're there. Types of governmental action.
Okay.
Legislative actions and quasi-judicial or quasi-adjudicatory actions. Legislative actions, policy-making decisions or general applications, such as ordinances or regulations, such as the building code. Types of legislative actions you may be taking would exactly be that. The chief building official, I quoted this from the code that we adopted, chief building official requests advisory comments regarding issues related to this chapter, such as potential adoption of new codes, proposed codes changes, or alternate methods and materials. In that situation, and you are a legislature, the ex parte, the limitations on ex parte contact is relaxed because, again, we're not making administrative record. I still discourage you from doing that because remember, the other part of you still, respect that, you still must disclose your ex parte communications because, again, the public's entitled not only to see your vote, but to participate in and that your deliberative process takes place publicly. So if there's if someone's met with each of you and argued for something and that never gets on the record and the vote is taken and why'd they recommend this? Well, it turns out that this, somebody met with each board member and sold them on this particular position and never got on the record because they never came to the meeting because they had their contact directly with the board members. That's the danger of ex parte contact, even from a legislative standpoint. But you're absolutely right. You have more freedom. You need to disclose it on the record if it takes place.
Because there's a bit of a tension there. In other words, we would feel a responsibility to bring concerns from the public, to the attention, and to be a means of expressing those concerns. Mm-hmm. But then you're saying the main way to address that is to accept those concerns as part of our advisory function, but to simply disclose who's communicating with us.
Yeah, and the substance of it. Although I still believe, your primary function here is as advisors to the city council. So, if you get a lot of feedback from members of the public, you can always invite them to come to the meeting so that everybody hears their point of view, and you don't be in the position of having to advocate or speak on behalf of an individual. But you're going to hear comments. You're going to bump into people. Someone is going to pick up the phone or send you an email. You're not going to forward that email to anybody else. But yeah, in that situation, then the right thing, the appropriate response is, thanks, I appreciate the information. Please come to the meeting, but I'll pass on your concerns to my colleagues at the meeting. The other good types of governmental action, quasi-adjudicatory, quasi-judicial actions, which are fact-based decisions relying upon evidence submitted. You're acting like a court or a judge. The important point for you to keep in mind about this is these actions are subject to challenge in superior court. So why much which follows after this comes into play. And of course, this is also taken from the code section. Any person adversely affected by a determination made by the chief building official in administering or enforcing any provision of this chapter may appeal the determination to the Board of Building Appeals. So that's the authority by which those would come before you. And here's the important, and this is laid out in the code. It's in state law, and we put it in our local ordinance. This is how the decision is made. The Building Appeals Board shall render a final written decision, or decision to be written, with findings within a reasonable period of time after filing the appeal. The authority of the Building Board to render written decisions shall be limited to the scope of the authority of the building official, and the board shall not have no authority to waive a requirement of this title. We'll get that if we get into the application of this, we can talk about that more. But basically, what you're doing is this is where, if you've been involved in city issues, dealing with CUPs or variances, where a matter is appealed from the Planning Commission to the City Council, the City Council considers it as if they're hearing it for the first time. You're a little more narrow here. You are actually just appealing to this determination made by the building official, reviewing what the building official did. You can't go beyond the authority of the building official. So it's a more limited review. Spend some time on, this is important, on findings. This is because we're not going to do this until you actually get a case, and then we're going to have to talk about it again. But this is important. Keep in mind your role as a quasi-judicial body. You're going to make findings. You saw the section that said you can make findings. What are findings? Why are they important? They're written or oral explanations of why, legally and factually, a public entity is making a particular decision. This goes back to new math and showing your work. This is not just, I think it's the right thing to do. It's very important that we connect what the issue is to the rule and the facts to get to a conclusion. Why are they important? It creates a record or explains the decision you made. You should be able to through your written findings and combined with all the evidence that's submitted to you, we should be able to reconstitute why that decision was made. It guides the decision-making process, and for me, it prevents litigation, because very often when someone challenges the decision the board makes, it's because they can't figure why they made the decision, and there's nothing to support your findings. So the better findings we make, better evidence we have on the record, if it doesn't discourage the lawsuit, puts us in a better place to successfully defend your decision. And of course, and then when we get into court, the court looks at what your record is. They don't rehold this hearing. The court looks at the resolution, the code, the evidence that's submitted. We actually physically make copies of everything that was submitted to you, and it goes to the court, and we have to reconstitute. And the court looks at it and says, was there substantial evidence in this record to support the decision you made? So the better the findings are, the better off you're going to be. Remember, findings should, this came out of a case, so you hear it from city attorneys a lot and land use attorneys, bridging the analytical gap in order to survive judicial scrutiny. Basically, how'd you get from here to there? So you might hear from me, bridging the analytical gap. That's what your findings must successfully do. Common traps. You can't say the code says so you have to do it. Another one is general findings like, this is for the good of the community. You need to make more specific. We must tie it to the law that we're enforcing. Words to avoid, and I'll help when we get to a case and we're conducting an appeal. I will be actually drafting the findings based upon the evidence that you submit, and you'll be reviewing the findings I propose. I'd put it in a document for you to review. But important things, avoid the words like might, may, perhaps, should, could. Instead, we want things like will, shall. Cite the evidence. This is really important. Cite the evidence. You might hear this, and I think the council members hear this from me from time to time when doing land use hearings. So in making that motion, you're relying upon the statement by so-and-so and the evidence from so-and-so. Yes, exactly. I'm relying upon that traffic information in the staff report. That's the reason for me to impose this condition or deny or approve this project. So citing the evidence is really valuable. And not going to come up a whole lot for you. All the evidence, the more we put in the record, the better off it is. So not just enough reasons, but a lot of reasons. If you're going to deny something, when denying a discretionary action, all the findings should support the denial. So, and you'll hear this from me if we get into a hearing. If it's equivocal, probably going to push you harder to really to point to all the evidence that supports the action you're particularly if you're denying the appeal. That all the findings should support the denial. Findings for denial are even more important than the findings for approval, because that's when the lawsuit's going to come, is when they're denied their permit or denied their appeal, if it's a denial of a permit, and therefore we anticipate more litigation. So actually, those findings are more important. If the person gets what they want, you're probably not going to file a lawsuit. State the project's impacts, cite the evidence, cite the statute, and bridge the analytical gap of why or how the impacts failed to meet the statute or the ordinance. Because I'm finding the application is denied because, and then you just cite it. I'm going to briefly cover CEQA for you, just because you'll hear it all the time. Most of the projects that you would get an appeal from are building permits that are generally exempt from CEQA, but it's completely interwoven into the land use process in California and local government. So at least this is not to be much more than awareness for you. CEQA, by the way, is the California Environmental Quality Act. If someone says SEQWA, that's also CEQA, but it's CEQA. So CEQA, the purpose of CEQA: disclose to the public and decision makers of the environmental consequences of a decision. It's not for approval or denial, it's a disclosure document. And there's a belief that it enhances the public confidence in the process with all this disclosure. And of course, one of the requirements is to identify significant environmental impacts of a proposed project and to review feasible alternatives that achieve the same objective with fewer significant impacts. So what is a project? Any discretionary activity undertaken by a private party or the city that may cause either a direct physical impact or reasonably foresees an indirect physical impact change in the environment. Types of projects: anything undertaken by the city, of course. Anything, in this review come into play, activity involving the issuance of a lease, license, permit, or other entitlement. And anything involving city money. So where you, of course, come into play is building permits and entitlements. Documents you're going to hear about are statutory and categorical exemptions. This is where a project is exempt from CEQA. It may be exempt because in the statute, in the California Environmental Quality Act, certain things are simply exempt. More often, there's the state has adopted a series of categorical exemptions. And so if your project fits into a category of various small things, small projects, then it's likewise exempt. It's staff's responsibility in processing a project to identify the environment, to do the environmental analysis and determine whether there's an applicable exemption. If there's not exempt, then there's two things. There's really three things you can do with the project. You prepare a negative declaration. You hear neg dec a lot. That's basically a finding that the project will not have a significant impact on the environment. There's a slightly newer document called a mitigated negative declaration, which means that you're able to establish some mitigations to the project that reduces their impacts less significant, therefore avoiding an EIR, environmental impact report. But it still gets circulated to the public and commented by the public, so it's still a fairly time-consuming process. And then, of course, finally, the big thing, which is EIR, environmental impact report. It analyzes the impacts, identifies mitigation measures, and evaluates reasonable range of alternatives to the project. This is the document. It's a large document. There's several steps involved where the project is scoped out. People and other agencies are entitled to review the scope of what the project is going to be and what the EIR is going to analyze. It's then circulated for public comment, and then afterwards it's finally adopted with mitigation measures. So CEQA for you should not become a significant issue, because the vast majority of what you're going to hear are going to be building permits, and in many cases, the building permit itself is exempt from CEQA as a ministerial action. It's not discretionary. If it's tied into a project that has somehow tied into some other project that has discretionary approvals, like a CUP or a variance or a rezoning, tied to a building permit, you may have CEQA before you. But I can't invent, and I'd ask Steve if he knows it, a case where as a board, you wouldn't be taking any action on the CEQA document. If we wind up with a case that does that, I'll provide you more intensive CEQA training before we get into that. But this is mostly just be aware. You hear these terms of neg decs, CAT exempts, EIRs. Just that process is going to be overlaying these things that you hear on appeal. Let's go back to let's talk a little bit about conflicts of interest. And this is not intended to give you. This is an awareness level training, so you identify issues and know when to ask a question. I'll start. I'm available to answer questions on behalf of city officials, and the FPPC, the Fair Political Practices Commission, is also available to answer questions. So this is, if you see an issue, hopefully if the issue pops up in your mind, you do something about it, ask a question. Please don't ask the question right before the board meeting meets. That's every hypothetical, and it happens. But the main issue is be aware of these issues so you know enough to, you see the agenda, you see the property, whatever it might be, you know to pick up the phone, you call Ann, you call me, you call Rob, or you call the FPPC, and as early as possible to know whether you have an issue or not. 4 areas of law here I want to talk briefly about. Political Reform Act, that's the main one we talk about, and Form 700. Government Code Section 1090 is probably not going to ever come into play for you, but you need to be aware of it because it's serious. It's a law that says that an official may not have an interest in a contract that they make. For example, the city council. The city cannot contract with a member of the city council. The contract is void. If they do so, it's a felony. The official loses their office, and the official loses the benefit of the bargain. So you sell your property to the city gives you $500,000, turns out the 1090 violation, the city keeps the property, and they get their money back. So that's the point. 1090 is a serious statute, and it's not enforced. It's only enforced by district attorneys and the attorney general. It's not enforced by the FPPC. But you have to be involved in the decision-making process. People like the city manager, the city council members, department heads, and in a few cases boards and commissions who have been given the authority to spend city money are the only people that encounter 1090. Incompatible office is a principle that's worth knowing. It's a matter of common law in California, which simply says that a person can't serve 2 masters. She can't hold 2 public offices that are incompatible with each other. And kind of like 1090 has a very severe implications, because if you take that second office that's incompatible with the current office you hold, you have deemed to resign the first office as a matter of law. And I should have put this closer to the top. Common law, there's also a body of law called common law conflict of interest. That's the case where you as an official have an inherent bias in a matter that prevents you from being fair and objective in decision making. And I'll give you a few cases of that. Big issue here is the Political Reform Act. No public official may make, participate in, or in any way attempt to use their position to influence a governmental decision if he or she has a disqualifying conflict of interest. Really important. It's not just voting. It's voting, it's influencing, or any way trying to impact the decision. So it's not, you can't just recuse yourself from the vote. You can't talk to people. You can't lobby people. You must recuse yourself completely from the transaction. Important point here is disqualifying financial interests. Your financial interests can be economic interest in a business entity, economic interest in real property, sources of income, sources of gifts, and your personal finances. So I've been doing this for 30 years as of next month. And this is still a very difficult area of law to be articulate about. About 10 years ago, the FPPC tried to come up with a process to help people just walk through the analysis, and they came up with this 8-step process, which I think is very, very good, because you don't even know where to start. You don't even, whether you have a conflict. You have to really analyze this before you know if you have an issue. So this is a nice thing to have. If you ever go to any training by some league departments, they actually create bookmarks and other things that actually have the 8-step on it. But I'll walk you briefly through the questions you ask yourself if you have a conflict of interest. Are you a public official? Yes. Easy. Will you be making or participating in a decision? So if it's something on the city council agenda, you're not making the decision, you're not advising the decision, it's not an issue. What is your economic interest? Is it income? Is it a client? Is it your property? Is it your investments? Is it a source of income, a gift you receive, someone's a source of income to you? What is the financial interest that you have? Is it directly involved? So if someone's before you and they're the appellant, that means they're directly involved. If it's indirectly involved, then it may have impact on you. The best example is directly involved is it's your project, your property. If it's indirectly involved, it's what you'll hear about is the 500-foot rule, that this project is within 500 feet of my property. So my property's not directly involved. We're not seeking the permit, but it's within 500 feet of my property, so I'm indirectly involved. In some cases, that makes a difference, directly versus indirectly involved. Is it material? And there's some standards for materiality. Is it reasonably foreseeable the decision will have a material financial effect? Big phrase. You're going to hear from me and almost every other municipal attorney. If in doubt, this is where you're going to hedge on the side of materiality. So this is one area I said, if you get all the way through there and you want to say, why it's not material. That's the hardest one to get off the train on, is that one. Two other rules that I don't think may never come into play for you. One is the public general exception. If you're making a decision, actually, I take it back. I will. Board of the building code adoption. If we're going to make some change in the local regulations of the building code, if it affects your property or your investment equally like everyone else in the community, then you don't have a conflict of interest. You may participate. There's tests on what the public general is. In a city as small as Ojai, it's basically the whole city. Where you probably don't have an issue is the legally required participation. And that's if we have so many people with a conflict, they can't take an action, and we're required to do something. And in my 30 years, I've not invoked this by no other attorneys that have. If we need to take an action and we don't have enough people to take the action, there's actually a process to draw straws to reconstitute a quorum, just a quorum. And then it's not to get the right number of votes to decide it. It's just to get to a quorum for you as 3. Then you would actually do a draw straws in a process to get to constitute a quorum so you can take the action that you're going to take. Let's go again. I'm not going to try to teach you all of this tonight. It's way too. But I want the issue to be aware of. Financial interest you can have as a business entity. If you have a direct investment or indirect investment in a business entity, you must disclose it. And whether you're a director, officer, partner, trustee, or employee, or in a position of management, and here's where the direct indirect comes into play. Indirect, materially based on increase or decrease in gross revenues at a specific financial threshold. Size of your business, outstanding stock, gross revenues of the company all change whether it's material or immaterial. If you're doing with the indirect interest. So if you have if you own a business that's involved in a decision before you or could possibly be impacted by the decision before you, you have to think about that. Real property, of course you own.
Quick question.
Yeah.
It says specified financial thresholds. What is the specification?
It depends on the size of the company. We have to go to the statute and the regulations.
That's where we talk to you.
Right. You say, okay, so if you own shares if you own a large business with a multi-million-dollar revenue stream, it's different than if it's a sole practicing consultant. So we have to go to the regulator. That's what I'm saying. This is, okay, my business may be involved in this. We're in the neighborhood, or it's the property next door to my business, or something like that. That's the awareness. You got to talk to somebody. Real property, very simple. Of course, you own property, but applies to leasehold interest, but not month-to-month tenancies. So if you have property that you're a tenant on a month-to-month basis in a commercial building that may be affected by a decision, that's not a financial interest. Leasehold interests are, I mentioned the 500-foot rule. This is great because for years we had to deal with a bullseye rule that if it's in so many feet, then it's presumed to be a conflict. If it's inside the next bullseye, then it depends on the decision that's outside the bullseye, and that was impossible to enforce. So thank goodness that the APPC adopted the 500-foot rule, and we enforce it strictly. If it's within 500 feet, you cannot participate in the decision or presume that it has a financial interest. If you're outside that, we're going to presume it's not material, but if there's something significant about the project, large project, fundamentally changing the character of a neighborhood, and it's 510 feet away from your property, you may still have to recuse yourself. And a test is, hey, this really bugs me. I don't want this to happen, or I really want this project. It's going to help me a lot. You probably have a conflict of interest. But for most of the time, that 500-foot rule is going to be the best rule for you, whether you're inside or outside. This deals with if you're dealing with any individuals or companies, I guess. If you have any loans with anybody before you, personal loans, you have to recuse yourself. Campaign finance doesn't apply to this. So campaign finance is not part of this. As a general rule, money flowing back to you and your brother-in-law is also not covered by this. So we're assuming, but any sort of, if you, the exception to the loans are, commercial loans, credit cards. If you have a mortgage and a credit card with Wells Fargo, and it's based strict commercial terms, nothing special, unique, you don't have much to worry about. If you're dealing in a community where you have actually direct loaning relationship with individuals or a very small bank or something like that, I think it's an issue you need to deal with if they come before you. Sources of income is any source of income that is directly involved. We're going to assume it's material. So if you have if that person before you is a source of income to you more than $500 in the 12 months, you must disclose it, and we're going to assume it's going to be material. There's some special rules about nonprofits. Don't need to get into it right now. And my number may be old here. 2 issues with gifts. One is there's 2 rules here, and we'll talk about Form 700 briefly at the end. There's a disclosure obligation. Any gift, $50 value or more in aggregate in a 12-month period, you must disclose on your 700 form. There's a cap, and I apologize, I think I didn't update my number. I think it's $475 now, is the most gifts you may accept from somebody. So now as a city official, you may not accept gifts in excess of, I think it's $475 or maybe $500 now, from any one source in a year. Again, relatives don't come into play. We're going to assume that relatives are fair gift givers, and it goes back and forth on a reasonably fair basis. But you keep in mind that if you're getting gifts, travel, rounds of golf, things like that from people who may appear before you, there's a cap on what you can accept. Period. Not just disclose, not just recuse yourself, but that you cannot accept. Let me talk again. I apologize. I think my number might be old. I don't know if this comes into play for you. The last one down here, gifts, not just obviously money, discounts, rebates, things like that. Anything there's a change in value is a gift. There's a general rule and prohibition of accepting honoraria. If any of you do a lot of public speaking, or if you're ever paid to do training or presentations, just let me know and I'll walk you through the honoraria rules. Again, we're going to assume family members that gifts among family members are generally exempt. There's a few narrow cases about people that have gotten large amount of money back and forth, but we're going to assume that it's a family relationship. Any decision result in an increase or decrease in personal expenses, income, or assets is deemed to be a conflict of interest if it's at least $250 in a 12-month period. That's income. That's not property values. That's just income you're receiving. Substantially likely is does that help? Reasonably foreseeable and substantially likely, both extremely difficult terms to figure out. In a small community, some of these factors are important because you bump into people a lot more. The types of things taken into consideration: the likelihood of them doing business with the city, their market share of income, how big they are in the community, what kind of competition they have. These are all factors we have taken into consideration to determine materiality. I'm going to talk about common law conflict of interest. Like I said, if you got a source of income, you got a gift, you got real property, you got a business involved in the decision before you, you got to contact me or contact the FPPC, and we can walk through those issues. I don't want you to try to resolve that on your own. There are good, if you want to go to the League of Cities, they have a good guide on conflicts of interest. You can, if you want to learn more about it. Talk briefly about common law conflicts of interest, and this comes into play because you're going to be administrative, adjudicatory, quasi-adjudicatory decision makers. A couple cases: Nasha versus Los Angeles. This was the planning commissioner who was a homeowner association issued the city newsletter, the homeowner newsletter that took a position against a project, and the project came before him. He voted, I guess he was the swing vote also on the project. Court held, yeah, it's a common conflict of interest. You took the trouble to write the editorial in the newsletter attacking the project. You can't then decide the project. Morongo Band versus State Water Resources Board. This is an issue that comes into play where it's my problem, much more my problem than yours, and the issue of advising versus advocating before a body. Same thing with Hoth versus San Diego. These are issues where it's mixed roles. You can't play two different roles in one decision. Nightlife Partners, another case that dealt with that, and that's the issue of advocacy versus advisory. Clark versus Hermosa Beach. This is the peeing on the front lawn case. This is the planning commissioner who had got into a neighborhood argument with his neighbor, resulted eventually into peeing on the guy's lawn. Then he winds up with this project before the planning commission, swing vote on the decision. Court said, yeah, you probably weren't fair and objective on that project. I don't know what's worse, the fact I have to tell you this, or that people would get this far and figure they probably shouldn't be doing this. The Culver City case, fairness is implicated where decision makers are personally embroiled in a controversy over the discipline of the police chief. This was an internal affairs issue. It wasn't a land use case. But again, the important point here is keep in mind you need to be able to be, you can have a position on that. You can be pro-growth, anti-growth, that's not the issue. The issue is whether in this particular case you have the capability to be enough removed from the facts of the matter and the parties involved that you can be fair and objective in the decision-making process. We talked about 1090. This was the case. Yes, Chacon is the case of the city council appointing a member as a city manager. Couldn't do it. We'll skip over some of these particular cases. They're just interesting. San Diego brings us a lot of bad conflict of interest. Isn't before the current former mayor. They always bring us great stuff. 1090, I told you before about 1090. The contract is void. The money goes back. The city keeps the benefits, and the official potentially goes to prison. Apologize for that. As I said, I took all the sound effects out of this. Again, this is an awareness training. This is not intended to make you an authority on these issues, and I don't want to take the time it takes to do a comprehensive, in-depth training on conflicts of interest. Bottom line is, if in doubt, if you don't want to talk to me about it, you don't want to talk to Rob about it, the FPPC has a very helpful and hopefully better funded helpline. They got very underfunded like everything else the last couple of years, and they were cutting their hours down to a couple hours every morning and a couple hours in the afternoon and not answering phones on Friday. But generally, you can call them, and if you leave a message, you'll get a call back the same day, and you can bounce your question. They know the regs, and they'll noodle through the regulation and maybe direct you to where you want to go. One thing, I don't have the slide. I must have dropped it. Another provision to keep in mind, if you seek my advice, it is not a defense. The only defense you can get for a violation is an opinion from the FPPC. So, you're going to get a very conservative advice. If you're your own personal attorney you talk to, you're going to get very conservative advice from those attorneys because it's not a defense. I asked my lawyer, he said I could vote, and then your lawyer was wrong. It's a problem for the lawyer, and it's not a defense for you in a potential prosecution case by the FPPC. So, after you go through this, you talk to the FPPC, you're not sure, it's close, you can seek a written opinion from the FPPC. I can help you write that. You can get a private attorney to help you write that. You get a written opinion from the FPPC. If they clear you, that's an absolute defense, even if it turns out they were wrong. And they're pretty good about, it's not a terribly long process. It's going to take you a few weeks. But there are ways, if you have problems with conflicts of interest, there are ways to get help in advance if you don't want to recuse yourself. A lot of advice say, hey, if in doubt, just recuse yourself. But if it's something you really want to participate in, you feel strongly about it, it's a touchy issue or it's a close call, you can ask for advice, and then you can get an opinion from the FPPC. And if you get that opinion from the FPPC, then you've got a defense. So there's my very, very brief Local Government 101.
I want to
happy to answer any questions.
Yeah, please. If I've been monopolizing questions. Anybody else? Please. I have one more, by the way, but I don't want to wait. little clarification on the mechanics
Yeah.
of dealing with the rendering opinions, the written opinions in the when we have an appeal. How do drafts of that get circulated amongst the board as we're coming to a
Would bring it to you.
individually, one-on-one? Is
No,
that-
no, no.
Okay.
Yeah, it's really important to keep in mind.
It has to be. That's what I'm saying. It has to be
Yeah.
done openly.
Yeah.
So you would bring a draft to the meeting.
Right.
And then we would accept it or not accept it and discuss it.
Correct.
Okay.
So normally what we do, depending on, I'm doing a personnel appeal for a city down in Southern California.
Mm-hmm.
It's a multi-night hearing. We're actually, after they complete the testimony, I'm going to go back with the staff. We'll go through all the evidence. They'll deliberate, and then I will, because there's a very thick, complex set of findings in the personnel case. Most of the time, just like we do with planning commission, most of the time, staffs can make a recommendation to you that you should approve the appeal or deny the appeal, and they will prepare you. Generally, what they do is prepare you the proposed recommended findings. Because staff's going to give you a staff report that submits whatever's been submitted by the appellant or on what they're appealing. The professional staff will analyze it, tell you what their analysis of it. And a recommended action of approval or denial that would normally include all the evidence that's in there and proposed findings. If you don't agree with the staff recommendation and want to go differently, then what we do is you deliberate among yourselves. And you say, we conclude the majority don't want to go staff's recommendation and act separately. Then we would go back, prepare a different resolution with the findings in it and submit it back to you at a subsequent meeting.
And in the interest of the ordinance is pretty specific about trying to act quickly, so we might end up having a series of meetings with pretty short notice.
Yes.
In that situation.
It really depends.
Yeah.
I mean, it's kind of hard to say right now exactly how I would do it. It depends. It might be we'll come back in next week. But normally, a week is more than enough. 2 weeks sometimes. But that's how we normally do it.
Well, hopefully we'll all be on the same page, but I mean, I'm just trying to think of all the eventualities here.
Right.
Of how that
I
would
guess
work.
the important point I'd like to make is to you as a hearing body, everything you do, particularly as a hearing body, it's important that everything be done in this room and you work with the professional staff in terms of putting this together. You're not, the purpose of having myself and the staff is to give you the professional advice and assistance in doing your job. It's not we're not asking you to go off and you guys got to type things up and put it all together. That's you've got the resources to help you do that, and so that's how we would normally handle it.
No other questions?
I have a question.
Sure.
And I don't know if this is the time to ask you or not, but what are the issues that are not appealable? What would not come before our board?
I was going to actually turn to Steve and ask that.
Typically, administrative provisions would not be appealable. If there's a city policy on how the city managers directed us to perform our function, that typically would not be appealable.
What about things like signs?
That is a zoning violation. It's not a building violation normally, unless there's a structural component to that would require a building permit. That could possibly be an issue, but it would be very narrow scope in looking at that. And it's not the size of the sign or the text of the sign or the location of the sign. Typically, it would be the structural elements of the size of the post. It wasn't designed to meet certain wind loads or something of that nature.
Okay. So is this time to ask?
That?
One other element of that is if it's a legal enforcement action where there's been a citation issued under the administrative provisions of the ordinance, then that would be fall into the city attorney's realm as far as the prosecution of that.
Yes, if we're done with talking to all of these
Sure you
legal
are.
matters, probably have more questions, but I think you're always open to any of us calling you.
Absolutely.
Or
This is-
or
yeah.
Mr. Clark or anybody
Yeah,
about this.
call,
you know.
call Rob, call myself if you have questions. I mean, again, I threw a lot of material at you. Again, my goal is really an awareness of the types of things that may come before you, and
Okay.
and maybe I might recommend that prior, or when you get your first appeal or something, if we know they're coming up, maybe we could have a prep meeting, do a little bit of prep on how to hold the hearing. And I haven't gotten into issue, we're not talking about how to actually
That probably
conduct
would be a
public
good idea
hearing.
when we get our first
Yeah.
request, that maybe we have a little training session on how to hold a hearing, would probably be a good idea. Well, the second, I appreciate your accommodating us on this first meeting with the second agenda item, because we all had, I think a number of us had some concerns, and as well, it seems to be a situation whereas the second dwelling program was passed in April of 13, I believe, the council's already asking for certain changes to be made in the program. And I think that a number of us have some issues we wanted to raise as well. So maybe I'll floor to you, Mr.
Sure.
Clark.
Before we go to that item, I just wanted to point out that we provided you with the municipal code section, the California Building Code, and the California Health and Safety Code sections that establish the legal basis for the actual duties of this board. And Mr. Stewart and Mr. Fletcher are here to respond to any questions you might have about what your actual duties are. And you may feel you've already covered that, but I just wanted to make sure that we noted that those were there.
Well, one question that did come up, and maybe this is the appropriate time to ask that, is that there's two appeals board in the Health and Safety Code, the local appeals board and the housing appeals board. Our initial, at least my initial read of this was that basically we are both, and wanted to make sure that we were clear on that.
Yes, we set that up so you serve all those functions.
Okay. Thank you. Any other questions on that item before Mr. Clark proceeds?
Okay, well, item number 2 has to do with the second dwelling compliance program. This is one of the primary programs included in our housing element to actually provide housing to people of low and moderate income level. And what it is there are many units within the community, we believe, that have been established without going through the normal permit process. And this is a methodology for bringing those into compliance with the codes. And so if a property owner has a second dwelling and it's not permitted, through this program they'd be able to come in, establish that they meet certain requirements for safe occupancy, and have that unit recognized under our codes as a legally conforming unit. So that was part of the housing element. In order to implement that part of the housing element, the City Council established guidelines. And those guidelines are in front of you right now. And as you noted, there are some changes proposed to the guidelines. But the main thrust of the guidelines are to articulate what type of issues need to be addressed by the homeowner in order to make their to receive recognition as a compliant unit. And so those have been spelled out there. The second part of what we have in the staff report has to do with the ombudsman program. There was a great concern as we were going through the housing element that people who have these units would be reluctant to come forward and turn themselves in until they know exactly what they're up against. So if you had a unit that for some reason couldn't be brought into compliance, or that was very expensive to be brought into compliance, or you feared that might be the case, you might not want to come to the city counter and say, hey, here I am, for the fear that your unit might be ultimately abated. So the purpose of the ombudsman program is to appoint qualified people who can be approached by homeowners anonymously, and who have enough knowledge and also who have access to city staff to get more knowledge so that they can help the homeowner determine what they have to do in order to get compliant. So this person would probably go out to the unit, take a look at it, and help them analyze what deficiencies they might have. And so there's a second set of guidelines for that. Now, as we've gone through the process of moving on to the next housing element, a number of issues have already come up, and I've listed those for you, and I'll kind of go through them briefly. But it is our expectation that as we roll this program out, we'll probably learn more, and we'll probably, as a result of learning more, want to make further modifications. So I think it's going to be a working document, and we'll consult you as we go along with that. So the proposed changes at this point in time are to the termination date. It was originally thought of as something that would be up and ready to go by July 1st of 2013, and obviously we're past that date, and so there's a need to extend the date. That's going to require an ordinance by the City Council, and they've already asked that ordinance be brought forward. Another item is garage conversions. In the original housing element, garage conversions were not included, and that was because of the fear that there'd be a parking impact. But as we're going through the next housing element process, garage units are actually something that we've said we will address. And so that's not addressed yet, but will have to be addressed going forward. Another item which came from the Planning Commission review of this was the need to encourage new second units. So not only does the program involve helping people get compliant who've already built a unit, but it's intended that we in the future will encourage people to build units that don't exist already. The fourth item is unit size. The current maximum in our code is 650 square feet, and in this program we also allow up to a maximum of 50% of the floor area of the principal residence. And during the council review of the fifth cycle, there were some questions raised about whether or not there's a need to provide for larger units than what this would allow. And so that's still an open discussion. Staff had also brought up an issue about setbacks within the VMU as to whether those setbacks really need to be adhered to or whether we should allow lesser setbacks, which is a more typical development department in that particular, or development standard in that particular zone. And then the last one is owner occupancy. Should we or should we not allow second units on a property where the owner neither occupies the initial unit or the second unit? So those are our proposed changes that are already on the table, but we'd certainly be interested in your thoughts and questions about other potential issues that we might want to address.
I know that Dales has an issue. Would you want me to?
I don't know if it's the time to discuss
Well, no,
it.
this is the time to add any issues,
Well, I have
because
an issue.
there is an issue that I know.
Yeah, it's on page 6, down at the bottom, report of building records. Now, that sounds like it's an inspection on sale. That's how it reads, and I would like to see that stricken from the record. I
And-
think that we'll have a revolution in town if we go forward with that.
And I think part of the issue there is, and I read this also in the packet, was it says commencing on a date that I'm sure will be changed when other dates are changed, all properties shall be subject to a reported building records ordinance. It doesn't say only ones that are associated with the amnesty or the second unit program. So I think that's the clarification. Is this a backdoor to
It says,
an
yeah.
inspection on sale program?
So, yeah, let me try and respond to that, and I'm sure there is some flexibility in how we deal with it. First of all, it is not an inspection. What is intended in the housing element and what is intended by this regulation and also the ordinance that implemented the housing element is simply a report of what's in the building file in the Community Development Department. So each property, each address has a file, and in that file are the various applications and permits that have been issued over time. And so the intent here is that the purchaser would be notified of their right to receive a report that says what's in that. Now, that's also information that they could come and ask for. The property file is a public record, and it's available for review. So, yeah, if we need to change the language, I think that's a very good point. We want to make sure that it's very clear that there will not be an inspection, because that is absolutely not what is intended. So the other, well, you could make a recommendation as part of this item that be clarified.
So we can draw it up and bring it back to you.
Or you could just recommend that it be done. You don't have to draw it up right now. Or if you'd like us to draw it up and bring it back to you, we could do that too.
Or maybe we can make the recommendation.
Yeah.
And then,
Well, my suggestion, if normally the process is that we would circulate something to you before a meeting so that the public has an opportunity to review it before it's discussed. So if you want to suggest how it should be written, I would request that you submit your suggestion to staff, and then we'll come back and we may recommend slight changes to it, or we may discuss those with you, but it needs to be on your agenda.
yeah, so maybe we can draw it up, and so there's a good clarification, and bring it to you, so we're not going back and forth on this issue.
Let's use our buttons, guys.
So there's a legal question about whether two of you can get together and draft a proposed up, and I'll refer to that to the city attorney.
This fine, I mean, you're a de facto ad hoc committee, I guess. I mean, maybe I can clarify, is there specific language in here that, I mean, you're objecting to, is it the ordinance you're talking about, or the language here that's in this?
And actually, before
You should discuss it right here.
Before you answer that question, I need to give you a little bit more information. The adopted housing element of the city has a much briefer statement that indicates that there will be a report of records program. So there is a requirement in our housing element that we have this program. Now, the specifics of it are not in the housing element. So I think you would have to look at the language that's in the housing element as part of deciding how you want to approach this.
Could you circulate that information to us then?
Sure.
If it's in the housing element and you're referring to it, that would be a standard
Yes,
request to just circulate that to us.
we'd be glad to do that.
Okay.
With the goal of doing, I mean, if you have questions right now, I mean, you can discuss, I mean, the bread price is right here. If you get problem with this language that's in this document here, this is where the time you guys should
Well, it
discuss among
says
yourselves what it should
That,
say differently than.
okay, it says that in entering an agreement for sale or exchange of any residential or commercial building on or after July 2014, the owner or his authorized representative, which means real estate agent, shall inform the purchaser of the purchaser's right to compel the owner to obtain from the city a report and blah, blah, blah. I mean, it's that kind of language that it sounds like, you know, if I'm the real estate agent representing the buyer, I'm supposed to tell that owner that he's got to get the record from the city about his property. That's, no residential owner is going to like that, whether he's absolutely compliant or not. He's just not going to like it. And as a real estate agent, I'm not going to like it.
So what the policy, and this is, we did not adopt this in the ordinance yet? We don't have an ordinance language?
I'm sure there is ordinance language. So you have housing, the tier is that you have the housing element, which initially established the requirement in a very brief way. Then you have language, and I don't frankly recall what exactly it says in the ordinance, but you have ordinance language which implements that, and then you have guidelines which implement the ordinance, and each level becomes more specific. So we may need to also review the ordinance language and see what's in there, and that's something that can be amended by the council if you recommend that it
Can
be
you
addressed by the
send us
council.
that language then, Rob?
Yes.
Okay, and then,
Well, and we did, but we have to schedule another meeting then.
We would have to schedule another meeting.
sorry about that,
Well,
but it's important.
I'm a little uncomfortable with it. If we send you something and it seems like then there's going to be some dialogue among members of the board.
No, I understand.
That's what I'm saying. It really should come back to you at a subsequent meeting with a staff report with him. We can send you a memo with the information, but we should plan on coming back to you with a particular document or for further discussion. I was going to ask, the policy is to require sellers to formally notify buyers they have the right to request through the seller of a building record.
A seller is supposed to tell his buyer, perhaps through the agent,
Yes.
that he has the right. Well, they're not going to do that. I mean,
Well, so,
policy.
well, so as I said, so you have two issues before you. One is is this too too harsh language in this piece of paper here, or is your objection to the policy, which has already been adopted by the City Council, to require sellers to give a notice to the buyer of their right to require this to require the seller? They can waive their right, but they require the seller to get them a building record. So that's policy. I mean, you're free. You're actually, to take a position recommending that not be a city policy, but that is city policy today. So that's my question: is it the policy that you're objecting to, or is it how we phrased it here that we could? Because I think going forward, we need to know which is the issue.
Yeah, I think all of it. The thing is that the way it's written, it's really not comfortable at all. And so I'd like to see either a suggestion from you about how it can be changed, or the language around it already that we have to work with, or however. But the way it's written here is not good.
Okay, so we can give you, at a subsequent meeting, the language that's in the housing element, the language that's in the ordinance, and then some proposed revisions to this language. And then, as part of your consideration, as Mr. Fletcher indicated, your advisory to the City Council. So you can recommend to the City Council that they change their policies, or you can recommend to the City Council that they describe their policies in a better way. So there's a number of options that are available to you when we bring this back. But we'll recommend something based on your comments today.
Okay. I'm sorry. I just want to ask one other question. If a person does come, someone with a non-compliant second unit comes to the city and they want to make it legal, is there some way that the city can help them with payment? I mean, to stagger it the way the sanitary district does with, like 5 years, there's no interest, and 10 years?
I think we actually do have the fee schedule in here. And what we've tried to do with the fee schedule is tie it to the fees that would have been in place at the time that it was built, rather than at the time that, the current time, which would be more expensive. So that's the current guideline that you're commenting on. If you think that that's not enough, you could also...
Many people, it's not enough.
Yeah, you can also...
They have a second unit because they're struggling to pay the mortgage.
If it's the feeling of the entire board that you'd like to recommend that we structure a payment plan, we could also bring that back at the same time, and you could look at that.
Mr. Daddy.
Mr. Clark, could you go back over, I think it was item 2, maybe I've gotten that wrong. It had to do with the size of the second unit to encourage second units being built. And the statement had to do with the unit. And it had a 50% number in there. And it says to the floor area, but that would still be subject to the maximum of 1,200 feet as to the state maximum of a second unit. So if you had a 4,000 square foot home, you wouldn't be able to build a 2,000 square foot. That is that same?
Correct. Yeah, it's limiting rather than expanding, I guess, would be a way of saying it. I think that's what you're saying. If you have a 4,000 square foot home, you couldn't build a...
Well, now it's 640, but what I'm saying now is there going to be some more clarity that says up to 1,200? I mean, people get lost when they see the number and they jump in and they go, hey, that's great.
Yeah, I think that was why it came up. I think there was a concern that it's not clear and a concern that it's not big enough. And so we will be coming back with recommendations about, or at least options for the size.
And I guess the question gets back to, are we considering dropping our restriction and using the state allowable number?
That's an option. We have not received a specific recommendation about the size. We've only been requested to bring it back to discuss. So that would be one option, yes.
I'm still digesting a lot of this material. But it does, and you correct me if I'm wrong, it does seem like the single largest financial issue is the sanitary connection charge. If that's incorrect, let me, please correct me.
Well, in some cases, I think it will be. That one of the things that the council's asked us to do is to meet with the sanitary district to get some clarification on how they'll handle this. But it could be, some units have been connected to the sanitary system and wouldn't be facing that. Other units are in places where the sanitary system is not available. We don't think, but we need to confirm that they would not be affected. But if someone actually has not been detected by the sanitary district and needs to have a hookup, that's very expensive.
Absolutely. Another lateral required for 640 square feet is, not, but, and the reason I bring this up is I've done a little research on this, and I started to read the sanitary district's code a little bit. And it's very interesting, and a lot that I don't understand. For example, they define the capacity charges to a capacity unit. But the capacity unit doesn't seem to be related to the way that a lot of other districts define things in terms of drainage fixture units. So in other words, you could have a very large house with a second unit that maybe would have as many fixture units or discharge as 2 or 3 smaller homes, and yet each residential unit is charged the same. And so it seems to be there's a number of issues there where more modern practices perhaps not being implemented by their code. I don't really fully understand it yet, but it seems to me that something that it is, I know there's no actual jurisdiction over the sanitary district, but certainly a discussion might be in order to hopefully see if they want to support the policy goal of the second unit program, rather being maybe the major financial impediment towards it being successful. And along those lines, would it be helpful for a couple of us perhaps to be named to an ad hoc group to work with staff on looking into this?
Yeah, we'd be glad to work with an ad hoc committee of this board if that's what your pleasure is. I think we'd probably have to put the appointment of the ad hoc committee on a subsequent agenda as well, though.
Yeah, I understand that. And let me get on to that next issue then. In terms of calling meetings, the ordinance specifies that the designated building official calls the meetings. If we want to request that a meeting be called for discussion of the kinds of things we're talking about right now, who is that person?
So we probably should have made some more introductions at the beginning of the meeting. But Ann McLaughlin is in the audience. She's the Community Development Director on an interim basis, and we're going through a recruitment for a permanent Community Development Director. But your main contact would be the Community Development Director. And that person can communicate with Mr. Stewart if that's what's necessary. So if you feel there's a need for a meeting, contact the Community Development Director. And then I'd also like to introduce Larry Beam, who's in the back there, and he's our deputy building official as well as our code enforcement and our building inspector. So this is...
Who's the alternative?
So is Larry Beam the alternative? If Ann were not available, who would be the alternative?
I would say if the community development's not available, let Sherry know, and Sherry will either communicate with the community development director or if not with me, and we'll make sure we get the meeting scheduled.
One other question, going back to the sanitary district. Is there a member of the city council that is a liaison to that district, or are we just kind of out of touch with them, or what?
That's a good question. We did have a liaison to the sanitary district for a while. I'm not sure where we are with that right now. Okay, we still do. Do you know who it is?
Yes.
We decided that the representative on the regional sanitation district would also serve as the liaison to the sanitary district, and I believe that's Betsy Clapp.
Well, I appreciate knowing who to contact, because as you can see, this group of volunteers is quite committed to doing what it can to get up and running and do the advisory function as well as getting trained to do the appellate function. So we may be leaning on you a little bit. We're not talking about 3-4 weeks from now. We may be asking for another notice of another meeting pretty soon on a couple issues that have already come up.
Well, I think if everybody has their calendar, we could actually schedule a follow-up meeting tonight before you adjourn.
Yep, that's fine. I think that's acceptable to everybody. Carlin?
This is a really easy question, but I believe that especially with a new group, any question is very important. So in the past, we have, like with the campaigns and this type of thing, if an individual had a question, they would send it to Rob Clark. Rob Clark would answer that question and distribute it to all of the members. That avoids a dialogue between, is that something we can do, especially in the beginning?
I'd be glad to do that initially. Typically, for example, with the Planning Commission, the Director of Community Development plays that role. But maybe at this point in time, since we're new, you could do that with me, and I'd be glad to disseminate it.
Do you have some suggestions for a date? Because you're probably as scheduled as fuller than ours.
Are Wednesdays the best?
Yeah.
So October 9th would be the opposite week of a planning commission week.
Yeah, I think that's probably a good plan. Would October 9th work for the?
What day of the week is that? I don't have Wednesday. That works for me.
And
everyone else?
And then the other question is.
I'll be gone, I'll be out of state.
You okay if we proceed?
Yeah. that's
Okay.
yeah.
Anybody else? Okay then.
And then
Thank you.
is 6 o'clock the best time? It's really open to your preference.
6 is good for me.
Okay.
Yeah. Thank you. Appreciate that. Okay. Well, I believe if we're...
So let me just say,
Yeah, please continue.
I know that this that the amnesty program is a lot of material and it's fairly new to you. If between the two meetings other questions come to mind, feel free to let us know what those are. So then we can be more efficient and try and address them in advance.
Well, let's be very specific. You are Ms. McLaughlin, should we come to, with questions.
Take your questions to me.
Okay.
At this point in time.
Okay.
Thank you.
We want to, because I think there will be some, because I think it's something that I think we all clearly take to heart the policy goal that the City Council has set in implementing this program, and we want to, I think our philosophy, at least my philosophy is, we try to work as in our advisory function on the front end as much as possible to avoid issues of appeals and everything else associated with that on the back end. So that's, I think, the philosophy we're trying to follow here. Are we done? Any other issues?
Well, I mean, so you're going to, can we circulate that information among ourselves, or we just write back to you and you circulate? How does that work?
What would happen in a situation like this is you would let me know what your issues are, and then I'll address all of your issues in a public staff report that's circulated with your agenda, so that if there are people out in the public who are interested and have input, they'll have an opportunity to see what's being discussed and what we're recommending.
Okay.
Mayor Blatz.
Yes, thank you. I just want to thank each and every one of you again for agreeing to serve on this board. And I can't tell you how absolutely ecstatic I am of the makeup of the board. Just the questions tonight, just the issues that you raised, just the comments. I'll tell you, it's exactly what I envisioned when it came to this board. And on behalf of Mayor Pro Tem Strobel, who I think feels the same way, this is a brand new body that the city has never had. And in our philosophy of having more community involvement, more input, more heads being put into to solve problems, I can't tell you how happy I am that this board came to fruition. And the makeup of the board, I just can't imagine it being made up of 5 more qualified individuals in our community. So thank you. I'm going to try to be at as many of the board meetings as I can. I don't believe there's a liaison to this board, and I don't think that it really is a different deliberating body, particularly when you're in a quasi-judicial function. So it's not really like the Planning Commission, not in certain aspects. So there's not a liaison that's been assigned, and there's always one extra council person every month that isn't assigned to a liaison to a commission, but this commission may not even meet in a quarter, or this board may not even meet in a quarter. So whether we have a liaison to you or not, I don't know. I'm going to try to be here just for the sake of watching the body deliberate. So thank you very much again. You have anything you want to add to that?
You guys look great up there. And the same as Mayor Blatz, I'll probably be attending as many meetings as I can for my own education, for my own clarification. Because if I don't understand what your function is, then I'm really not very much help to you. So that's why you'll see me at the meetings. And just incidentally, we have a newer speaker system. You can actually turn on all your mics and leave them on.
Thank you.
But the downside of that is if you turn to your neighbor and speak, everyone will hear it. So the advantage of turning your mic off is that you have some privacy. But you can, we've updated the system, turn the mics on, leave them on. We don't have the feedback problem anymore. And it's more convenient than reaching out and hitting that button all the time.
Thank you so much, and I'm not sure we deserve the accolades, but we are going to do our best to reach your expectations for what I think we all understand needs to be done. Thank you. Are we ready to adjourn? Guess I'm supposed to do this or something? We're adjourned. Thank you.